Hello guys, I am about to continue our report entitled Dworkin, the Moral Integrity of Law. I am Robert Carl Emopalek, your discussant for this topic. So let's start with liberalism. What is the meaning of liberalism first? It is a political and economic doctrine that emphasizes individual autonomy, equality of opportunity, and the protection of individual rights, such as primarily life and property, originally against the state and later against both the state and private economic factors, including businesses. In Dworkin's perspective, there is such a thing as liberalism, and the opinion is suddenly popular even there's nothing. Politics label themselves as liberals, held for certain positions that could be identified as a group. Ang kanilang layunin ay para sa higit na pagkakapantay-pantay, para sa ekonomiya, for internationalism, also for freedom of speech and against segregation, for a sharp separation of church and state, for greater procedural protection for accused criminals, for decriminalization of morals, offenses, and consensual sexual offenses involving only adults, and for an aggressive use of central government power to achieve all these goals. Kaya isang halimbawa na rito ang ating bansa. Mayroon kasi tayong kalayaan na magamit ang ating karapatan sa pamamagitan ng pagsasalita, paggawa, at pag-iisip nang walang sinumang kumokontrol o nagmamanipula sa atin. We are all free to speak out our feelings or thoughts regardless on the issues that are existing or we are facing. From the familiar phrase liberal causes and those who promoted these causes could be distinguished from another large party of political opinion that could usefully be called conservative, which are the contrary position to each of the classical liberal causes. Dworkin believes that the government must treat people as equals. His analysis of political morality has three ingredients: justice, fairness, and procedural process. As what I have mentioned, the politicians who labeled themselves as a liberal leads to have equality to the people of the nation. It gives them freedom to do their practices with the supervision under the existing law. In Dworkin's analysis, there are three ingredients of political moralities as what mentioned on the screen: the justice, fairness, and procedural process. The justice recognizes both individual rights and collective goals by the legislator dedicated to treating citizens with equal concern and respect. Fairness is the procedures given to the citizen that are approximately the same influence in decisions that affect them. And procedural process relates to the correct procedures for determining whether a citizen has violated the law. These three are the foundation of political liberalism. Upon of this, his purpose is to define and defend a liberal theory of law. Dworkin also launched the numerous forays or plunder, or called pandarambong, against the enforcement by the criminal law of private morality, the idea of wealth as a value, and the alleged injustice of positive discrimination. Well, kaya ito ang gusto niya dahil gusto niyang labanan ang ideyang positivism, conventionalism, and pragmatism. So sa kanya kasi, wala sa mga teoryang ito ng batas ang nagpo-provide ng equal or adequate defense para sa karapatan ng mga individual. Ito raw kasi ay batas lamang na tumutukoy sa integridad, which is affords a suitable defense against the instrumentalism upon individual rights and general liberty. Law as literature. Judges are like interpreters of a developing story. They acknowledge their duty to preserve rather than reject their judicial tradition. So the key component of Dworkinian legal theory is its claimed affinity to literary interpretation. Dworkin argues that when we seek to understand it in a particular way, we must portray it accurately. So, gaya ng nalalaman natin, yung mga husgado o hukom, sila yung nag-i-interpret ng mga batas kapag nasa session sila kasama ng ilang mga mambabatas. They therefore develop in response to their own beliefs and instincts theories of the most constructive interpretation of their obligations within that tradition. Just like a novelist who makes a single novel out of the previous chapters, endeavoring to write a chapter so that uh, the ultimate result will be coherent. This requires a vision of the story to find the meaning in the evolving creation and an interpretation that best justifies it. Dworkin maintains that law is like a literature that is need an interpretative concept. Semantic theories, such as those proffered by legal positivists, fail to explain the essence of law. Debates concerning whether evil laws are indeed laws are sterile if conducted at semantic level. This merely relates to the meaning of law at what Dworkin calls the pre-interpretive stage. It becomes a more stimulating and significant debate at the interpretive level, for then the question becomes not one of mere semantics, but one about the substance of law. For someone to claim that Nazi law is not law then represents a skeptical, interpretive judgment that Nazi law lack those features vital to flourishing legal systems whose rules and procedures justify coercion. This is, in effect, a political judgment. Next is law as integrity. Dworkin offers the following description of its important elements. By securing a kind of equality among citizens that makes their community more genuine and improves its moral justification for exercising the political power it does. As a constructive interpreter of the preceding chapters of the law, for example, Hercules, the superhuman judge, will espouse the best account of the concept of law. This obliged Hercules to inquire whether his interpretation of the law could form part of the coherent theory justifying the whole system. So in Dworkin's view that it consists in what he calls law as integrity. So what is integrity? It is the act of behaving honorably even when no one is watching. So, people with integrity follow moral ethical principles in all aspects of life. They extend to professional areas at work such as decision making, interacting with colleagues, and serving customers or clients. That's why integrity is more of a quality than a skill. So what the screen shows, Dworkin offers a description of its important elements. The law of integrity or the law as integrity accepts law and legal rights wholeheartedly. It supposes the law's constraints benefit society not just by providing predicability or procedural fairness. It argues that rights and responsibilities flow from past decisions and so court as legal, not just when they are explicit in these decisions, but also when they follow from the principles of personal and political morality that explicit decisions presuppose by the way of justification. So the collective application of coercion is defensible only when a society accepts integrity as a political virtue. This enables it to justify its moral authority to exercise a monopoly of force. Integrity is also a safeguard against partiality, deceit, and corruption. It ensures that the law is conceived as matter of principle, addressing of members of the community as equals. In short, an amalgam of virtues which form the essence of the liberty society and the rule of law, as Dworkin has now called it, legality. So the question is, why do we value the law? In my opinion, we value the law as the set of rules that we need to follow, or it gives us a right to choose and to live without any act of discrimination or unequal acts in the society. Well, in Dworkin's perspective, it suggests that while an efficient government is laudable, there is a greater value that is served by legality. It is a concern with the moral legitimacy of the law, which is a primary element of Durkheim's legal philosophy. It is based in the large part, or rather the imprecise concept of community or fraternity. So as a political society that accepts integrity becomes a special form of community because it asserts its moral authority to use coercion. Integrity entails a kind of reciprocity between citizens and an acknowledgement of the significance of their associative obligation. A community's social practices spawn genuine obligations when it is a true, not merely a bare, community. This occurs when its members consider their obligations as a special, personal, and based on the equal concern for the welfare of all. To generate political obligations, a community must be a true community, which is they support the ideal of integrity that can be a genuine, morally legitimate, associative community because its choices relate to obligation rather than naked force. Dworkin's conception of a political community as an association of principle is a powerfully attractive one. That's why comparing the judicial function to the process of literary criticism accentuates the positive portrayal of law and the fundamental role of judges within it. Next, the law and value. Dworkin's Justice for Hedgehogs takes its title from Isaiah Berlin's celebrated reference to Archicolaus' aphorism comparing the fox and the hedgehog. This claim is fundamental to Dworkin's theory that oral values are both dependent, subjective, and objective. Dworkin used fox and the hedgehog because the fox knows many things but the hedgehog knows one big thing. That big thing is what Dworkin calls the unity of value. It endorses what he calls Hume's principle uh, that carries the facts around the world, or human nature cannot normally ordain what ought to be. He argues the Hume's distinction between fact and value, far from encouraging philosophical skepticism, because the proposition that it is not true that genocide is morally wrong is itself a moral proposition. And if Hume's principle is sound, that proposition cannot be established by any discoveries of logic or facts about the basic structure of the universe. In Hume's principle, properly understood, it supports not skepticism about moral truth but rather the importance of morality as a separate department of knowledge with its own standards of inquiry and justification. In Dworkin's theory, it claims that the oral values are both independent, subjective, and objective, because he insists upon the autonomy of arguments of value, rejecting the idea that external forces could induce the conflict between our values. Instead, we should adhere to our value judgments, justifying them by reference to our more abstract values. We are responsible for making our moral views as clear and coherent as we can, and we are obliged to make our lives as good as we can. So we must live with dignity, which requires not only that we take our lives seriously, but that we also assume responsibility for our lives. Living a life of dignity promotes self-respect. This is a question of ethics. In addition, we owe moral duties towards others. For Dworkin, moral questions are an extension of ethics. By acknowledging the significance of self-respect, we are obliged to recognize its importance in the lives of others. Almost every element of Dworkin's wide-ranging theories has provoked energetic and occasionally even rancorous debate. His ever-expanding group of dictators adopts a variety of standpoints from which to launch their assault upon what is a large and sometimes moving target, and there are no signs that the disagreement is likely to diminish. That's all, and thank you for listening.